divisive some liberals can be in defending Obamacare. Yale law professor Akhil Reed Amar blasting Florida federal judge Roger Vincent, saying his law students understand the Constitution better than Judge Vincent does. He also compared Judge Vincent's ruling striking down Obamacare as, quote, unconstitutional, and allied it with the Supreme Court's 1857 pro-slavery Dred Scott decision. So what does all this say about the majority of Americans who disapprove of the health care reform law? Here to score it for us are Chapman University School of Law Professor John Eastman and Jim Martin. He is president of the 60 Plus Association. Gentlemen, good to see you. Professor Eastman, when I saw this, I mean, for God's sakes, affiliating or associating Judge Vincent with a decision in support of slavery. This guy's a Yale law professor, not Judge Vincent, but the guy who wrote the piece. What do you think of this?
Well, I have a great deal of respect for Professor Amar normally, and in fact he's been at Chapman Law School and we've had wonderful exchanges. And the first part of his article, that this is a close call on constitutionality, I think there's decent arguments to be made that it is constitutional. I think they're wrong, but they're decent arguments. But the comparison to the Dred Scott case and Roger Taney is just beyond the pale. This case has nothing to do with that. The issue involved is whether Congress gets to do anything it wants that has anything to do with the economy under the Commerce Clause, the power to regulate interstate commerce.
And he brings up, we should mention, the professor who wrote this piece in the LA Times brings up the Implied Powers Act, the fact that Congress does have implied powers that are not enunciated in the Constitution. He makes his legal argument, as you suggested. But to throw this in at the end, to suggest that anybody who believes, as Judge Vincent does, that Obamacare is unconstitutional is somehow affiliated with pro-slavery forces. That is just weird.
No, that's right. And the connection he makes is that Justice Taney overturned an act of Congress, and this judge is overturning an act of Congress. That's as close as the connection gets. It's preposterous. He also makes a rather significant error. He says Chief Justice Marshall, in his whole 34 years on the court, never invalidated an act of Congress. That's just flat out false. The whole notion of judicial review comes from the famous 1803 case of Marbury versus Madison, when they held that the parts of the Judiciary Act that Congress had adopted were unconstitutional.
All right, so he was wrong and he was hyperbolic. But Jim Martin, the fact is he's also going against the grain of the American people. At the very least, 50% of the American public are against this law, and there are some suggestions it's even more than that. So if you paint 50% of the American public as being on the side of slavery, if you're against Obamacare, you've got a problem, don't you?
Well, clearly he is grasping at straws. When I first heard that, I thought surely he is jesting, but apparently he's serious. Look, the semanticism used here is trying to obscure the fact that the public has voted overwhelmingly to get rid of Obamacare. Look, I applaud the judge's ruling in my home state of Florida and the one in Judge Hudson in Virginia, where I now reside. But the fact is, we say, let's suspend this thing right now until the Supreme Court decides. And we say suspend it, the sooner the better. Because quite frankly, I believe, unlike the professor there, I believe it's going to be repealed. I really do.
Well, the professor, this professor agrees with you, but Professor Eastman, what about that? Stopping Obamacare, any implementation, because we've already seen various forms of it, not the biggest parts of it, but some parts. Suspend them until the Supreme Court comes to their decision. What about that?
Well, I think that's a very good idea, and certainly in the 27 states where it's now been held to be unconstitutional, Virginia with the ruling there by Judge Hudson, and the 26 states who were involved in the Florida case, I think for the administration to press ahead with implementation of Obamacare violates the court's declaratory judgment of holding unconstitutionality. And Judge Vincent said, I'm not supposed to need to issue an injunction when something's unconstitutional. It's presumed that the government will act in accord with our constitutional rulings. And so until that decision is stayed, they need to comply with that. And if they don't, I think Judge Vincent may well issue some contempt of court citations.
Wow. Well, Jim Martin, that's the legal side of the issue. What are you doing on the popular side? How are you getting the people together to call for halting implementation until the Supremes decide?
Well, first of all, in the political scene, of course, senior citizens, more than any other segment of our society, last November, They spoke loudly and clearly. And if I could invoke a word this week, it's President Reagan's birthday, of course, and we remember those ringing words about the Berlin Wall. Mr. Gorbachev, tear down this wall. I can hear seniors saying last November, Mr. Obama, deep six this bad bill. It is not for seniors. It is clearly not for the public. We think we need to start over. We say repeal it. Don't repair it, as some of these senators are saying. It's beyond repair. We need to start over. You know, there's an old saying in the medical profession, first do no harm. This thing now has caused so much havoc already. Seniors see rationing on the horizon. There are at least 2 drugs we know of that are starting to be rationed by Dr. Berwick at HHS.
The head of Medicaid and Medicare. Well, Professor Eastman, what about a death by 1,000 cuts? We know that the 1099 rule has been pulled from Obamacare. Is it conceivable that there will be so much cutting of the law over the next couple of years that eventually there won't be much left?
Well, I think that's true, but the precedent, if the rulings are not challenged and upheld that this is unconstitutional, the precedent they will set. Next time there's a supermajority in Congress of people that want to expand government, they'll come back around. And the fact of the matter is we're perilously close to losing the notion that our federal government is one of only limited powers. Obamacare is on the proposition that we can do whatever we want out of the federal government, and I think that's why Judge Vinson and Judge Hudson have shut it down. It's why the Supreme Court has recently revived the notion that there are limits on federal power, and I think, quite frankly, there's a very good likelihood that there are 5 justices there right now that will hold that Obamacare is unconstitutional.
Professor John Eastman, Jim Martin, good to see both of you. Thanks for coming in. Coming up.